All right. Good afternoon. Good afternoon. Good afternoon. Again, this presentation is being recorded. See, got myself there. My name is Brian Seymour. I am the program manager for the Made in Baltimore program. We are a program of the Baltimore Development Corporation, which is our city's largest economic development agency. The work of Made in Baltimore is aimed at supporting and promoting makers and manufacturers here in Baltimore City and helping to grow the buy local movement in the Baltimore region. We offer business development services and resources to small batch manufacturers, makers, and retailers. We do this through programs like this workshop series, Tools of the Trade. Today, we are here with Linda Hutchison from Hutchison Law LLC to discuss developing a strong enforceable trademark. Linda is a member of Hutchison Law LLC, where she focuses her practice on intellectual property law. Linda helps clients navigate the trademark registration process, copyright registration process, as well as the patent process. Prior to working as an attorney, Linda worked as a management consultant and manufacturing engineer. Linda draws from her management consulting and business experience to help clients select, acquire intellectual property rights to support business strategies. Linda is also a senior adjunct instructor at Howard Community College, where she teaches business law and introduction to business and organizations. Linda graduated from the University of Baltimore School of Law, sharing a Master's of Arts in Administrative Management, Public Administration from the University of Maryland University College. Linda earned a Bachelor of Science from Chemical Engineering from Northwestern University. Listen, stacked. You guys are extremely lucky today. We ask that you please remain muted through this presentation. We would love to see your faces if you are comfortable. This is a safe space, a safe learning space, so there's no such thing as a bad question. When you have a question, please quietly add it to the chat and it'll be answered during scheduled Q&A segments. Again, do not feel pressure to keep up with note taking. This workshop is being recorded and will be posted on our website at a later day. Thank you to our parent agency, Baltimore Development Corporation. And thank you to you all for giving us your time today. And with that, I'm going to hand things off to Linda to get us started.
All right. Thank you, Brian, and thank you everyone for attending this discussion. And with the group here, hopefully we can have a really encouraging and informative discussion. And I will try my best to look to the chat as you're asking questions. And if I miss it, I'll catch it at some point. There are times when I'm going to ask you to see if you can put some answers in the chat just to kind of get us engaged with the discussion. But let's get started. Okay, before we begin, and I'll be talking about myself a little bit later, and I'm actually speaking on behalf of the Maryland Volunteer Lawyers for the Arts, and I'll be talking more about them later as well. But before we begin, before we delve into some details, I want to tell you a story. Okay, so we all know this is beach time, or as I say, I'm from New Jersey, so I say shore time. So this is beach time. This is when we're all going to the beach. We're hitting the ocean or hitting the wherever we're going. Maybe it's the lake actually, and or wherever. And we are just searching out that fun time during the summer. And one of the things that happens when my family hits Ocean City or something like that is they instantly say, "Okay, where's the coffee?" I mean, it's almost the first thing they say after they throw down the towel, the beach towel, and they look at the ocean. Okay, we need some coffee. So let's go find some coffee. So we hit the boardwalk, and this is what we see. We see 3 coffee houses right next to each other, or maybe they're not next to each other, but we're walking along the boardwalk, and we see 3 coffee houses, and all of them say coffee, coffee, coffee. So you're standing there on the boardwalk and you're going to ask yourself this question: which coffee shop do I enter? They all say coffee. Which one do I enter? Do you have the information to know where to go? And you walk a little bit further down the boardwalk and you see another string of coffee houses. And one says coffee, one says Starbucks, and one says coffee. Another one says coffee. So based on that, let me just make sure I can get the chat viewed. Oh, whoops, okay. Based on that, you can make a decision. All right, I like Starbucks coffee, or I like Starbucks specialty drinks, like if it's wintertime, their peppermint mocha, or I like their, lemon iced bread, or I even, their bathrooms are good or whatever. But based on the fact that you see Starbucks and the others say coffee, you're going to make some decision about where you want to get your coffee. Oops, let me make sure I did it right. Okay, so then you walk further down the boardwalk. Maybe it's a different day. You're walking further down and you see one that says Starbucks, but it's spelled a little funny. And then you see a coffee, and then you see Starbucks. And again, it's spelled a little bit differently from what you're used to. And so you're going to ask yourself this question. Okay, I want Starbucks coffee. Do those have Starbucks coffee? Which shop has Starbucks coffee? You don't, it's maybe they have. Is that, even though they're spelled a little bit differently, does that mean that they have Starbucks coffee? So the next day you're walking along the boardwalk again. I mean, my family loves coffee. So the next day, or maybe even just an hour later, you're walking along the boardwalk again. And this is what you see. You don't see Starbucks, but you see Moonbucks, and you see Sunbucks, and you see Planet Bucks. So you're seeing all those either aeronautical terms or astrophysics terms. And you're thinking, okay, I mean, are these Starbucks? Or, you're asking yourself, which shop has Starbucks coffee? So again, it's kind of, I'm not sure which one has Starbucks coffee, but maybe I assume they all do, because they're all dealing with stars, sort of, kind of. So then you're walking down the boardwalk again. This might be later on in the day. You're just walking around. And then you see 3 buildings next to each other. This is a very long boardwalk. And you see 3 buildings next to each other. One says Starbucks Lawyer, one says Starbucks, and one says Starbucks Home Goods. Okay, so based on what we know, we can kind of think, all right, the middle one looks like it's probably the coffee. But then you can kind of ask yourself, did Starbucks really start expanding its services? I mean, you kind of, did Starbucks expand into legal services, and did Starbucks expand into home goods? And based on that, if I ever need a lawyer, should I go for that Starbucks lawyer because I really like Starbucks coffee? Or should I go for those tables, the tables or chairs or lamps sold at Starbucks Home Goods because I like Starbucks coffee? I mean, you're asking yourself, has Starbucks expanded into these other goods and services? So just walking down this boardwalk, just seeing all these different buildings, and some of them are specifically coffee houses, you think, I am so confused. You're the consumer and you don't know where to go. I mean, people have these signs up, and you think, logically, you maybe should be you should be able to clearly, very easily identify what business you want to be a patron of, but it's really confusing. I'm very confused. I'm a consumer and I'm confused as to where to get my coffee. So the goal of trademark law is to stop the confusion. So we've just experienced what a consumer feels like, and when things in terms of trademarks can be confusing. And the goal of trademark law is to stop that consumer confusion. We don't want consumers, the law does not want consumers to feel that kind of confusion. So that's what that's kind of the underlying theme of today's presentation. And as I mentioned earlier, I'm actually presenting on behalf of the Maryland Volunteer Lawyers for the Arts, which is a great organization that helps provide pro bono services with respect to, for people involved with the arts. So there's copyright, trademarks, and things like that. And our title of our presentation today is Developing a Strong and Enforceable Trademark. And the story that we just walked through, walking on that boardwalk and seeing all these buildings, that's kind of story is sort of the, the foundation of our understanding of how to develop a strong and enforceable trademark. And again, my name is Linda Hutchison. All right, so let's start getting into the weeds. Before we do that, let me walk through the disclaimer. I'm just going to read it. I'm an attorney, so I got to read the disclaimer. Opinions and conclusions in this presentation are solely those of the author, unless otherwise indicated. This presentation provides general information and is not intended to be and should not be taken as legal advice. This presentation is not intended to and does not create an attorney-client relationship. Legal advice must vary with individual circumstances, and do not act or refrain from acting on the basis of this presentation without consulting professional legal counsel. So again, I am presenting on behalf of the Maryland Volunteer Lawyers for the Arts, so please contact Maryland Volunteer Lawyers for the Arts when you come across any issues. Okay, so let's move on. So before we delve into trademarks, I'm going to just do a high-level discussion of intellectual property. First, we have copyrights, which protects expression. What I want you to think about when you're thinking about copyright is, for example, logos are more than just a trademark. Logos are actually somebody's artwork that's been put into to function as a trademark. So sometimes logos and artwork is protected by copyright. So a logo, for instance, might have trademark rights and also copyrights. A trademark under the law, it's identified as a source identifier for goods and services. That's the legal definition of a trademark. It is a source identifier for goods and services. In other words, it has to be associated with goods and services or it's not functioning as a source identifier. And then there's patents, and patents are going to protect novel technologies, processes, and design. So these are the main types of intellectual property. There's also trade secrets and variations of trademark like trade dress and things like that. But when you want to know just the gist of things, there's copyright, trademarks, and patents. I'm going to be focusing today on trademarks. So let's look at this definition here. Again, a trademark under the law is defined as a source identifier for goods and services. That means a trademark doesn't just float around. It's not something that's in a sentence, used in a sentence. It is something that's marking a good or services. And by marking that good or service, it is identifying you as the source or identifying the owner of that trademark as the source of those goods and services. And how do I think about it? I think about it as it's this beacon that's calling to your customers. When you first meet a consumer or a customer for your business, you're going to be beginning the process of developing the goodwill with that customer. You're going to be providing those quality services. You're going to be providing those quality goods. You're going to be providing all the bells and whistles that you as a business owner are able to provide to your consumer. That second time that business or that consumer needs those things, they're going to be looking for your trademark on that building or looking for your trademark on that good or service sold in stores. And it's going to act as a beacon calling your customers back to you. I mean, I've had people say, well, it's going to take time. Well, of course it's going to take time. I mean, that first introduction to your consumer is that, they don't know you. And so but after that first time, they start associating you or your business with your goods and services, and that trademark acts as a beacon. Basically, that's how I like to say it. It's acting as a beacon calling to your customers back to you. So what are examples of trademarks? This, again, is just part of the language to understand that we use when we're talking about trademarks. We have a word mark. So a word mark is just words, and such as Starbucks, but then there's also design mark. And the design mark in this case includes the mermaid, the circle, the words in the circle, the stars, the use of green. So again, when we talk about trademarks, we're talking about both word marks and design marks. And how are trademarks used, or what are some examples of trademarks? Well, it could be a brand name, like Starbucks. It could be a slogan, such as "Just Do It" from Nike. That's a slogan, and it's actually a registered trademark. Could be logos, like the Starbucks logo. It could be sounds. There's a certain sound for a TV. I don't know if it's NBC or ABC. One of those actually had a certain sound, and that was registered as a trademark. Trade dress, the bottle, the Coca-Cola bottle is actually functions as a trademark, and it's not actually a mark. It's the shape of a bottle, so that's identified as trade dress. And by functioning as a trademark, again, it identifies Coke as a source of that of the Coca-Cola, and from my perspective, it basically draws the consumers to the Coca-Cola goods. So it's acting as that beacon. And then it also can be characters, like you see in the MGM logo right here. The lion is part of the trademark. So these are all different examples of trademarks. So what does a trademark do? what does it do? Well, it can be used to inform or educate or express opinions. As you see here, the article references the trademark, and it says Under Armour and dozens of footwear brands request halt to higher tariffs. So in that respect, it's sort of referencing the trademark in as the business, as the brand, right? And then in that case, sort of the word mark. It's not being used as a trademark in that case. It's just being used in a sense, but it's referencing the goods and services. But then it's also part of advertising, marketing, and promotion. As I said, in that case, that's when it's functioning as this beacon. You want your consumers to come back to you after, I got to give the consumer that first initial meeting, but after that meeting, when you've made an impression, you want that consumer coming back to you, and that trademark is going to act as that beacon. And in that way, it functions in your advertising. It's functioning as part of your marketing, in terms of, who are you targeting? And it's also functioning as part of your promotion. So with all of these functions and with all of these uses, I would suggest that all of us who own our businesses, that all of us view our trademark as a business asset. And intellectual property is a business asset. It is something that if you sell your business, the value of intellectual property is actually considered. And a trademark is one of the strongest parts of your intellectual property as far as value goes. I mean, when you think of the Starbucks logo, nobody's going to want to buy a Starbucks franchise, or nobody's going to want to buy the Starbucks business unless it comes with that logo, because that's what's going to drive the consumers to continuously come there. So when you think about something as a business asset, and if you're into 3D printing, or when you think about your equipment and things like that, and those are part of your business assets, your supplies, and also your inventory, those are business assets. When you think about all these business assets and you're putting your time and your money and your focus into those, I would suggest that you got to view the trademarks the same way. It's not something to be just thrown away. It has so many uses, as seen on this chart. It has so many uses that if you think of it as a business asset as well, then you can leverage it and really get the full power of it. All right, so let's revisit the beach. So here we are, we're walking down the boardwalk, and we see the 3 coffee houses, and they all say coffee on them. So what I'd like you to do in the chat is answer this question. What business strategy would support a trademark owner spending money to develop a mark that is not distinguishing? And businesses do this. So let's just kind of talk about the strategy. Like, why would a coffee house have a trademark that says coffee on it? So if you can go ahead and put that in the chat. See if I can. Anybody have any ideas why? Give you a little bit of time to answer. Now, why, if you were a coffee house, why would you use coffee as your trademark? See if I can get a little bit more time. Anybody? Okay, so it actually makes a lot of sense when I talk to marketing people, and they're thinking of content for their marketing, for their websites and things like that. Those people are saying, I want to tell the consumer what I'm selling. Okay, so if I'm a coffee house, it makes logical sense to me, if I want to max out, my promotions and things like that, that I'm going to put coffee as my trademark. But there is an issue. From a trademark perspective, trademark law does not recognize marks that describe the good or service. So in that respect, it's not giving you any benefit as a trademark. Putting the word coffee on a coffee house, it's not a strong trademark. It's not an enforceable trademark. It's really nothing from a trademark law. You're not treating it to its full extent as an asset, right? You are telling people what you sell, though. And so some people have chosen to do that. And so throughout this entire presentation, my argument is use your marketing content or use your websites or your brochures or your menus to tell people what you sell. But again, use that trademark as that beacon to bring people back, to bring people to you, because they identify your sources of good, you as a source of goods and services. However, and also over time, sometimes if you have a descriptive mark, if you demonstrate that you've used it for over 5 years and you prove that people associate that descriptive mark with your goods and services, you might be able to prove that you actually have trademark rights. But generally, you want to avoid a descriptive trademark. Leave that to your marketing content. Okay, I see a hand. All right. Okay, so yes, question.
Hi, I'm driving, so I have to put my video not on. The question is, you talked about the coffee shop and you talked about the dollars to use for trademark. And you said coffee wouldn't be the one, but you didn't say what would be the one.
And we'll be going through that.
Oh, okay. Okay. I thought I might have missed something.
No, not yet. But you're doing it. This is perfect because I'm creating the need, right? In the discussion, I want to create the need so I can fill it in. So right now, perfect question. We're identifying what's not great. So in order to identify a strong and enforceable trademark, I'm first showing you what's not strong and what's not enforceable.
Exactly.
Okay. So very good question. Hopefully I will be answering your question before the presentation is over. And if not, hopefully I can get some more information to you. Okay. So very good question. All right, on to the next one. All right. So now let's look at this. You're walking along and you see Starbucks spelled funny, coffee, and another Starbucks spelled kind of in a funny way. And so I have a question for you. What business strategy would support a trademark owner spending money to develop a mark that is confusingly similar to Starbucks? So if you can take some time and answer in the chat if possible, if you have any ideas of what kind of business strategy, what is the business strategy that would support this? Anybody has any ideas? If the company's still trying to write on so okay, yep. Predatory business practices. Helps identify. Okay. Oh, so you know what? I think I missed some of the. I think you guys were writing stuff before, and I just didn't get it. So I apologize. Okay. So now we're talking about helps identify. All right. So I think in this case, I see people have answered. If they're trying to ride on the Starbucks identification, it could be viewed as a predatory business practice. Maybe some sort of twist. Well, let's see what the law says. Actually, I just want to say all those make sense. I have run into people working with trademarks who have said, I know that Nike is famous and I know that everybody respects what they sell. So if I want to sell stuff similar to what Nike is selling, doesn't it make sense that I kind of leverage the goodwill that Nike has developed? I mean, people, that's a normal way, people are talking about business strategy. That's a normal business strategy. However, I'll answer that in just a minute. What about this one where you have Moonbucks, Sunbucks, and Planet Bucks? So that brings up the next question is what business strategy would support a trademark owner spending money to develop a mark that suggests an association with Starbucks? So the first one, the prior one, we said that is confusingly similar to Starbucks. So what about this one? That would, if I saw Moonbucks, I might think, oh, is that a Starbucks subsidiary? Or, Sunbucks, is that a Starbucks? Is that associated with Starbucks somehow? So why again, in the chat, please, why do you think someone might do that? Trying to capture a similar market share. Okay, that's very fair comment, very good comment. Anything else? Why would somebody want to kind of assume an association with an organization like Starbucks Coffee? Get more business using another name. So again, that kind of also goes back to what we were talking about before, where the name was confusingly similar. because they respect the integrity and quality of Starbucks. So if they say, okay, if I call Moonbucks, I mean, it's not the same as Starbucks, right? It's not the same, but maybe somebody assumes an association to attract customers. If you have customers going to Starbucks, and you know that they, then maybe if you do Moonbucks and you say, well, it's not the exact same, but maybe they'll consider you because they like Starbucks as well, right? Okay, so I see a hand going up. Yashia, what?
Interesting. I'm a Starbucks drinker, right? So wherever I see Starbucks, whether I'm in Baltimore, whatever state, whatever country, I like, okay, the Starbucks, I'm going to drink it. But sometimes you could go to some Starbucks that are not quote unquote Starbucks, but have picked up the franchise, like Target and some of the grocery stores have picked up the franchise. And I'm like kind of not leery about it, but sometimes they say it's the same, but I'm really not too sure. So I don't patronize them if they're in I guess I could give them a chance, but I just.
Yeah, if they're an actual legit franchise, and I would assume with Target that it's a legit franchise,
Right.
Target wouldn't want to mess with any kind of trademark infringement cases. That theoretically, if it's a franchise, it's supposed to be functioning the same as the parent. So maybe give them a chance. If you don't like it, go somewhere else. Okay, Brianna, what comment do you have?
Can you hear me?
Yes.
Yeah, so my comment was specifically about the Starbucks thing. I remember my campus, when I was on campus, they sold Starbucks coffee, and they sold the cups with the symbol on it, but not the name. And they never named it Starbucks. And I'm pretty sure that University of Maryland would have never wanted to get in trouble with Starbucks to do this. So I've often wondered how that works, where places are able to either sell the company's products or use part of the logo without it being an infringement, right? Like without it being a lawsuit.
Right, and we'll be talking about the design marks and versus the word marks, and they are both trademarks. And you bring up a fair point, which is one of the things is if you develop a strong trademark and then you franchise or whatever, you can license that mark. And so, right, University of Maryland most likely licensed it, and it depended upon if it was the actual logo, then they licensed the logo, and they were responsible for having the product at the standard of the Starbucks product. So hopefully we'll be also delving more into both of your comments as we move forward. Okay, so we've got this one. What about this next? You're walking along the boardwalk, you see Starbucks Lawyer, Starbucks, which is the coffee, the original place, and then Starbucks Home Goods. So my question for you is, what business strategy would support a non-coffee business owner spending money to develop a mark that's confusingly similar to the famous Starbucks mark? Whoops. Yeah. So if people want to, go into chat. How's that? Okay, why is that not working? There we go. People want to, why would a law firm want to call themselves Starbucks Lawyer? Why would a home goods store want to call themselves Starbucks Home Goods? Excitement over name recognition. That's a fair point to attract customers. It could be their last name. That's a fair point. Attract customers. Yep. So again, those are fair points. So initially I said, well, trademark law does not support a trademark that's descriptive, right? If it's coffee, as far as trademark law is concerned, it's not a trademark. It doesn't function as a trademark because it's descriptive. Now we've gone through 3 scenarios where basically people are trying to get that name recognition from Starbucks. And here's what the law says. Trademark law does not enforce trademarks that create confusion in the marketplace. So if our trademark sounds similar to Starbucks, but spelled differently, that's going to create confusion. Again, that's the story I started off the discussion with, is that a consumer can stand there and say, I'm not sure where I'm supposed to go. Similarly, with the moon bucks and the sun bucks, there's confusion. Did Starbucks now are these subsidiaries? And then with the Starbucks lawyer and the Starbucks home goods, again, those are all legitimate kind of ideas as far as marketing goes and as far as promotion goes, but the law is not okay with it. Trademark law does not enforce trademarks that create confusion in the marketplace. However, they will let Starbucks enforce its mark against those people who try to create confusion in the marketplace. So all those people who are using the word Starbucks but spelling it differently, Starbucks is going to send them a cease and desist letter or take them to court. All those people who are using moon bucks and sun bucks and everything, those are confusing enough that Starbucks can send them a cease and desist letter or take them to court. Similarly, Starbucks lawyer, that's going to be told that that's a trademark infringement because the mark is so famous. Starbucks homes goods, Starbucks can go after them for trademark infringement. So those are all, so even though all those things, everybody created those trademarks based on a strong business strategy. We want to leverage what's out there. We want to leverage the market that people know. Trademark law is saying we're going to stop you from taking advantage of somebody else's goodwill and hard work and promoting their trademark. Okay, so now we've gone through, these stories, and we've started looking at what trademark law and what trademark law will do. So again, to this point, we have seen confusion from the consumer's perspective. You have stood on a boardwalk and you have seen where people have created trademarks that could confuse the consumer as to where am I supposed to go. So what I'm saying to you is we need your trademarks to act as a beacon and not confuse the consumer. Don't try to leverage, somebody else's trademark. One, it's going to get you into trouble, but two, you're confusing the consumer, your own customers, right? You're definitely, if you're, one of those Starbucks scenarios, you're confusing the Starbucks customer, but you're also confusing your customer. You want to create a logo that is a beacon, that's so strong, it's a beacon to your consumers to come back to you. And then we have also seen where the law allows Starbucks to go after those trademark owners, those, the incorrectly spelled Starbucks, and the ones that seem to create an association, and the one that leverages Starbucks in different industries. The law allows Starbucks to go after the owners of those marks for trademark infringement. So you don't want to put yourself in a situation where you are actually setting yourself up for being sued. Okay. So number one, you want a mark that gets your consumers to you and doesn't create confusion in the consumer about your consumer. And two, you don't want to put yourself in a vulnerable position for being sued. So those are some of the things we're going to be focusing on. Okay, so the goal of trademark law is to stop the confusion. Your goal when you create a trademark should be to stop the confusion as well. You want a very strong beacon that does not confuse a consumer with any other marks in your industry, or any other, or famous marks for that matter. Okay, so what is a likelihood of confusion? What creates a likelihood of confusion? Well, here we have 7-Eleven, but we also have a store created this mark that said 7 Super, and it, under the law, was actually viewed as infringing on the 7-Eleven trademark based on a likelihood of confusion. When is there a likelihood of confusion? Well, the marks are similar. The goods and services associated with the mark are similar. Again, a trademark is not abstract. A trademark has to be tied to some goods and services and identify you as the source of those goods and services in order for it to function as a trademark. So, so you've got to make sure you know what goods and services you're selling with your trademark. And then there's a famous mark, famous marks. Yeah, the font's too similar. Famous marks, and then it's very fact specific. For instance, I have worked with someone where they were trying to develop their trademark, and everything looked very unique and very different, but their font was the same as a major player in their market. And so I said, they're going to come after you for that font. That font really clearly belongs to that other business, and they've established their goodwill associated with that mark. And so I'm like, you might want to, I recommend you change that font. Okay, so these are some of the things considered. It's not just exactly how they look, but it's similar. One of the things that really I have to explain, that's tough for people to understand sometimes, is all because you change an S to a T and a Z, or all because you add an S or something like that, it's still a similar mark. And the law will view you, if you're using, if you're in the Starbucks situation, adding 2 R's and adding and getting rid of the U or something like that, as far as the law is concerned, you are still infringing on the Starbucks mark. So again, we want to create something that doesn't create confusion with anybody else, so you're not vulnerable, but also that is so strong and so distinguishing that it acts as a beacon for your consumers. What are some other ways where we find our mark that we are putting effort into developing is similar to somebody else's mark? So if they sound similarly, so if they appear or if they look the same, again, that goes to font and that goes to use of colors. So if you're selling farm equipment and you happen to be using that John Deere green, you're setting yourself up, you're putting yourself in a vulnerable place for trademark infringement. So that's not, so you're not developing a strong trademark. Also, meaning and translation, if your mark is merely the foreign word or the foreign translation of a famous mark, as the law will say, well, tell us what that mark means. And then if it finds out it's the same or similar thing, then you're setting yourself up for being on the receiving end of a lawsuit. Also, commercial impression. So for instance, if you decide that you have a coffee house, or even if you're just selling coffee beans, or even a bakery. Again, a bakery is sort of associated with coffee. So if you're a bakery and you're selling goods that have a big circle that's green, that has maybe not a mermaid in there, but maybe like 2 mermaids in there or something along those lines, arguably, Starbucks can say, you are confusing the consumer because the commercial impression is the same of the trademarks. The commercial impression is this fanciful, ocean being in a circle, and the law will say, well, we're saying the consumer is going to have the same commercial impression. And then they look to similarity of goods and services. Again, it doesn't have to be the exact same mark. It doesn't have to be the exact same goods and services. It just needs to be related goods and services. As I said, a bakery, someone can argue that if you have a bakery, the goods and services are related to what a Starbucks coffee house is selling as well. And similarly, like if somebody sells sneakers, someone who sells socks or shoelaces, those are related goods. And so you have to think about not having similar trademarks to what's out there. And then bottom line is, you don't want to confuse the consumer either as to an association with a mark that's currently in use, as to or as to that they in any way are associated with you, or that you are them just spelled differently. So we've got a question. Okay, Brianna, what's your question?
So I don't know. I know the age-old one is like Ralph Lauren polo versus like Polo Assassin. And I've also wanted to know, like, how do companies get away with that for so long? So if you look at the two differences, the one difference is that there are 2 people on the horse of the Polo Assassin, and there's 1 person on the horse of Ralph Lauren polo. And I've often wondered, because they make very similar clothing and very similar styles of things. And I've often wondered, how do companies like proceed in this, right? Like, because we do see them existing. How do they maintain their own company while like technically infringing upon someone else's trademark?
Yeah, I mean, I don't know enough about the relationship between Polo and Polo Assassin. I mean, on the surface, the only thing I can guess is that they're licensing the right to use the word polo, because it does seem, I mean, you bring up the good points. In a normal scenario, if the one company has polo and another company has polo with a couple extra words on it, and they're on similar goods, I would view that as trademark infringement. So I actually don't know how they're getting away with it, unless there's some sort of licensing scenario, or maybe there's some sort of subsidiary. And if they're not, then I don't know how. Maybe they have some sort of, again, they might have some sort of consent agreement or coexistence agreement that allows them to do this, and maybe they're paying for it. I really don't know, but you're hitting on exactly what the issue is. We don't want to set ourselves up when we're going through the effort of creating a trademark, and that's supposed to be a beacon for our consumers. We really don't want to have it similar to somebody else's. We want to avoid that, so that the consumers aren't confused, and also that we don't put ourselves in a vulnerable place. So that's a great scenario, and I'm not sure why it's okay. It doesn't make sense to me, unless there's some sort of agreement. Yeah, I really don't know.
Yeah, if you have the time, I would take a look at it. It looks very similar.
Okay, so yeah, I don't know. Maybe there's something that we. Okay, so let's see. Great local Baltimore IP store. The Brewers Art had a beer named Ozzy, and the can had knuckles of the name Ozzy on it. Yes, that makes sense right now. What's interesting is in this case, I'm not sure if Ozzy Osbourne sold beer, but there is a standard for famous marks, and that's actually the Starbucks scenario. The Starbucks lawyer scenario that I brought up actually happened. There was an attorney that wanted to take advantage of all those people who love Starbucks and try to use a trademark called Starbucks lawyer, and actually try to get it registered. And it was denied registration because it was trying to leverage the goodwill of a famous trademark. So even though, Ozzy may not be selling beer, or the word Ozzy may not be on beer for Ozzy Osbourne, the Ozzy is a famous mark, and it doesn't matter what you use it on. So that's a very good example. All right, so again, when you're thinking about developing a trademark, it is not a case where your mark is in trouble only if it's the exact same as somebody else's, and only if it's on the exact same goods. You really have to look at concepts of similarity of the trademark and similarity of the goods, and just think, hey, let me just make something unique. Let me truly make something unique that acts as a beacon to get my consumers to come to me. Let's not mess with putting ourselves in a vulnerable place. All right, more reasons why trademark law does not support enforcement of a trademark. One is if you use your last name, that's not viewed as a trademark. Now, McDonald's, people are, what about McDonald's? Well, over time, just like that one where I talked about the descriptive mark, over time, the law may say you've developed, your mark has existed long enough that people now know that surname is associated with your goods. But generally, if you just use your surname, it's not viewed as a trademark. It's not even viewed as a trademark under the law. Similarly, with geographically descriptive goods, any client of mine or any client of anybody's in Maryland who uses the word Chesapeake, if Chesapeake is in there, from the law's perspective, it's not viewed as an enforceable part of your trademark because it's geographically descriptive. If it's associated with Maryland goods. I mean, if you're selling stuff in California, if you're selling suntan lotion in California and you call it Chesapeake Sun or something, something like that, and it really had nothing to do with the Maryland and the Eastern Shore, then maybe you could get away with it. But again, if it's geographically descriptive of your goods, it's not viewed as a trademark. So it's not even that it's a weak trademark, it's not viewed as a trademark. It doesn't function as a trademark under the law. Then we look at individuals' names and likenesses. The trademark office, the United States Patent and Trademark Office, is really getting very strict on this. If you're using other people's names or likenesses in your trademark, they're going to say, do you have the consent to use that person's name and likeness? And then also sometimes people say, well, I've written this book and I want to trademark it. That's the sense. I want to trademark it. And I'll say, well, the title of the book is not a trademark. So what is it that you want to trademark? Well, do you have, I'll ask, do you have some sort of logo on the back of the book or something, that identifies you as the source of that goods? Because the title is not a trademark. Okay. So here's an example. This is kind of going back to what Brianna was saying, in terms of what is a trademark and what is not, and when is there infringement. So in this case, this is really talking about what is a trademark and what is not as far as ornamental use. So if you have a trademark on a shirt, the law is very specific on how it must appear in order to be viewed as a trademark, and then an enforceable trademark with trademark rights. So in this case, on the left-hand side, it's got to be in the upper third of the shirt. Generally, it's going to be on the pocket, and it's going to be fairly small. On the right side, even though that may be the trademark for polo, in this instance, the way it's being used, it is not a trademark. It's just a design on a shirt. So if you want to sell shirts and you want your trademark on the shirt so you can enforce your rights against others who are selling shirts with a similar trademark, well, make sure you're using your trademark as a trademark. Put it in the upper third of your shirt, put it, make sure it's small and it's functioning, or put it on the tag in the back. That acts as a, if you put your trademark on the tag, that's a trademark. and put something else, put some other design on the shirt, okay? But or you could put your logo as a design on the shirt, as long as, if you want to enforce trademark rights, as you're still using your logo actually as a trademark. It has to be either on the like a lot of people will put their trademarks on the tag in the back, or somewhere in the upper right or so of a shirt. So shirts have a unique thing. People say, I'm gonna sell shirts with my trademark on it, and I'm gonna enforce those rights against others who try to copy or create a kind of similar trademark. I say, well, you got to make sure you use the trademark as a trademark and not as an ornamental design. All right, so how do you figure out, okay, I'm kind of blocking my words here, whether your mark might fall victim to likelihood of confusion? So that, again, that means that your mark is weak and not enforceable because you are now vulnerable to some prior user of a mark. How do you avoid that scenario? How do you avoid this scenario? Number one thing you can do is searching. So the United States Patent and Trademark Office has a search system called the Trademark Electronic Search System called TESS. And you can use TESS, you can type in your trademark and the words of it and see if it comes up and other people are using it in similar, for similar goods or for related goods. So that's a great thing to do. It actually can be fairly complicated because, as I said, if I'm searching on Starbucks, I'm going to search on a bunch of different variations of Starbucks. Well, actually, I'm not even going to search. I'll tell, if a client asks me to use Starbucks, I'll be like, you might want to think of something else. But if I'm searching on Moonbeam, okay, Moonbeam coffee, which really, that's different enough, I think, that it could legit be a trademark. If I'm searching on Moonbeam, I'm going to search on MUN, MOON, BEEM, BEAM, MNBM. I'm gonna search on a bunch of different variations because, again, one of the things for likelihood of confusion is sound. So if it sounds like it, and I'm gonna even add plurals to the end, if it sounds like it, then and it's already out there, I don't want to infringe on somebody's mark. I don't want to put myself in a vulnerable place. And you could also search on graphics as well. So the test system allows you to search on graphics. There's also the Maryland for state marks. Now, what's interesting about state registration is that gives you state rights within that state. When you're dealing with the United States Patent and Trademark Office, and we'll talk about this in just a minute, that gives you priority rights nationally. So whenever a client asks me where you should rate, I always go national. Then there's the common law rights. You actually have rights as soon as you use your trademark where you're using your trademark. So if you are selling goods in Maryland and you have marked your goods, then you have rights in your trademark under common law where you're using your trademark. Now, interestingly enough, that still means, that sure you have rights, but that doesn't mean that you did a good enough job creating a trademark that someone can't come after you for infringement. So make sure, again, this is a business asset. So make sure you've done your due diligence and come up with a unique mark that doesn't infringe on anybody else's, that's not descriptive, and doesn't assume an association or create confusion in the consumer, and make sure it acts as a beacon for you. You can also do business, whenever somebody asks me to do a test search, I will say, well, have you done searches on these other things as well? Because a test search is only going to look at whether or not marks are registered, are similar to your mark. But you want to know if there are businesses out there that are using their business name as your trademark, because they can say, well, we've been in business 20 years. You just started using your trademark, cease and desist. Domain name searches, that's another one. And then there's a place I actually outsource for searches is CompuMark. So if I'm doing a very comprehensive search, somebody's starting their brand from scratch, and they said, Linda, we want to make sure we're not going to put ourselves in trouble, I will recommend a very comprehensive search through CompuMark. And then, of course, first and foremost, always do internet searching, because you can see if it's out there before you go into these more sophisticated searches. You can see if it's out there. You can see if variations of it are out there in related goods or similar goods or whatever. Let me look at this question. Research. Yeah, so research, right. Jamelia, research, Jamelia, is really very important, because this is what we're doing. So we're doing the searching, and this is a necessary step. Is searching a perfect science? No. It's an art, and you're doing the best you can. But if you skip this step, you're really putting yourself in a vulnerable place. What else? Well, we recommend, as an attorney, I recommend that people register their trademark. Does that mean that your mark is perfect? Your mark is totally going to be totally strong and distinguishing and all these other things. Ideally, yes. If you look at the federal registration, it's split into two things, the principal register and the supplemental register. Let me talk a little bit about each. So the principal register, what happens here is if your mark is distinguishing, it's not descriptive, another mark, it's not similar to another mark, and it makes it through trademark registration at the national level, which is through the United States Patent and Trademark Office, the USPTO. If you make it through registration, to the point of registration at the United States Patent and Trademark Office, there is a presumption that you are the priority user of the mark. And use is really what it comes down to. People can use their marks without registration, right? I mean, you can, and that goes back to that common law thing. You have rights where you're using it, whether you're registered or not. The registration gives you this presumption and it gives it nationally. So if you're not using your mark in Nebraska, but if you have a national registration, you can send the cease and desist letter to somebody in Nebraska who's using a similar mark on similar goods or services. And also, then only at the national level do you get to use that circle R. You can use the TM when you're using your mark under common law, and you can use that TM, the TM to identify your trademark as a trademark. You can use that when you get state level rights, but only when you get national level rights do you get the circle R. So do not use, because it's kind of fraudulent, do not use that circle R, or potentially fraudulent, that circle R, unless you've gone through the national level registration process. And it's also, if you find that there are infringing goods coming in or imitation goods coming in through our borders with a mark that's similar to yours or confusingly similar, you can register your mark with the Customer and Border Patrol based on your registration, and that will help to stop those imitation goods at the border. And this will also help you bring any kind of claim in federal court and help with federal registration as well. So what about the supplemental register? If your mark is descriptive, and I mentioned earlier, some people will use a descriptive mark because they want to just tell people what they're making, right? My argument is, well, that's what your other marketing materials are for. Make sure that your trademark acts as this beacon, this unique beacon. But hey, if you end up creating a descriptive mark, it can be potentially registered on the supplemental register. And then over time, if you use it long enough, you may be able to establish rights strong enough that you can apply on the principal register and then get that presumption of priority user. So that's, so the supplemental register, it allows you to use a circle R, but when you're on the supplemental register, you're basically admitting that your mark isn't strong, that it's a weak mark, and that you're going to take the time to create consumer awareness of your goods and services associated with your mark. And at some point down the road, you will have to prove that you've done that and get onto the principal register. Okay, so a few more things. And again, this is focused on the national level registration. So I recommend you don't avoid descriptive marks, avoid marks that are confusingly similar to other marks, avoid marks that are assume an association with another mark, avoid marks that assume an association with a famous mark. And then I also recommend that you do go for the national registration, just to give you that presumption, that legal presumption of being the priority user. And it does cost money. So the recommendation is at least start with your word mark, because a lot of times people will have a logo, like with the Starbucks. People will have a logo, but within the logo they have these words, and the words are the strongest part, are viewed as the strongest part of the logo. So start with the word mark, and then it costs the filing fee is about $250 or more per class. So if you're selling, like Starbucks has tons of trademark registrations. One is for the coffee mugs that have, if they're selling coffee mugs. One is for the logo that's on the actual coffee house. One's for the actual service of coffee. Each one of these, one is for their gift cards. Everywhere they use their logo, it's not just one logo, it's a different class of goods. And so each one of those is a different application for registration. And then, part of the application, if you're not sure what trademark you want to use, but you have an idea and you just want to go through the registration process so that when you start using it, you can use that circle R, you can file what's called an intent to use application. That's very helpful when you're developing. It also will give you the feedback. So USPTO will go through the searching process and within the USPTO help you understand whether or not someone else is already using that mark. And it's also very country specific. And as I mentioned, there's some overlap. For instance, with the logo, you have art that is protected under copyright, and the use of the trademark is protected under trademark law. All right, so that is, how do we do on time? So that is everything. And again, if you have any questions, please contact the Maryland Volunteer Lawyers for the Arts. They're an incredible organization that helps entrepreneurs like yourselves. And and they have clinics. I think once a month they have clinics where people are available to help with things. All right, so at this point, I am opening it up to questions.
Say, do not be shy. If you have a question, please take advantage of this time.
Well, I think I don't know if I just want to kind of reiterate, so what is the process for developing a strong trademark? People had asked, and my focus was really on how to avoid developing a weak and a vulnerable trademark. And so basically just sort of flip that. I mean, really find things that are unique. My business, I'm a lawyer, my trademark is a polar bear. What does a polar bear have to do with providing legal services? Absolutely nothing. All right. What does a mermaid have to do with coffee? Like Starbucks mermaid? Absolutely nothing. All right. So if you can really think about, when you develop a trademark for your business, you want it to be strong. You want it to not put you in a vulnerable place, and you want it to be a beacon, right? Be a beacon. So think about outside the box. Think about outside the box. I have to hop on. Thank you so much for that. Oh, okay. You're welcome. Okay. All right. Let's see. I see people with hands up, but I'm not sure if those are from before. So Jamila, do you have your hand up now? And Shia, do you have your hand up now, or is that from before? It might have been from before.
I'm Jamila. I do have my hand up.
Oh, okay. Okay, great.
I think just to confirm. So basically, like if somebody, let's say for instance, I wanted to trademark the term box art, but like if somebody's already using that for their business, or maybe they're using that to describe what they do, then that would not work as something to.
It could, if they're using it to describe what they do. Again, then they're not using it as a trademark. They're just using it. But if they're using it as a trademark, it depends on whether or not it's in a similar industry to you. For instance, if I was selling wine and I use the trademark boxer, that might be okay, because I'm not sure if there's any boxer trademark out there associated with wine. If I was selling, forks, and I had the trademark boxer, that might be okay. So it really depends on the goods and services associated with your trademark.
Okay, because like just for it, there was one thing that I was thinking of using box girls, because it describes it. It is like my type of art, but there's an organization called Box Girls, and there's actually girls that box. So I really didn't think that was something that I should consider.
Yeah, I mean, right. I think that's very smart it's smart to avoid putting yourself in that vulnerable place. So that's a really great business strategy approach, right? It is interesting though. It's interesting if they're in the same, for instance, if they function in the same place where you're going to be selling your stuff, you might be putting yourself in a vulnerable place. I think you're smart to try to avoid it, but the word box plus some other things after it isn't bad to use. You just have to, I think you're thinking the right way. And so maybe start with box, but use something else. I mean, again, it's industry. It's, if yours is art and they have to do with a gym, I don't necessarily see overlap there. But at the same time, if it's famous enough, that they can say, hey, you got to stay away from our trademark, then you do want to avoid putting yourself in that vulnerable place. And at all times, you are thinking the right way. Bottom line is you're thinking the right way. You're thinking as a strong trademark owner, business owner. And so just kind of, maybe come up with something else that still uses the word box.
Yeah, I'm thinking, I'm just kind of now, like you said, trying to pivot and just find other terms that still may not describe what I do, but help people identify what my mark is, but steering clear of what someone else is doing, I guess, just in terms of the visual,
Yeah, and one of the interesting things is, and I remember I gave a presentation once and someone said, well, it's going to take time. If I make my mark so distinguishing, my consumers won't know. I was like, well, they'll know after the first time they talk to you. Right. Right. I have a polar bear. I have a polar bear for a trademark. People are like, what the heck? And I said, well, after they talk to me that first time, they remember the trademark because they're like, oh, that's that attorney with a polar bear. And I've actually had conversations with consumers because my trademark is so unusual in my industry. So so that first time, getting the consumers to you, that's where you're putting all your work into your copy content, your marketing copy and things like that. But again, once they're there, if your trademark is so interesting and so different, that's going to act as a beacon to bring them back, along with the goodwill that you develop through your goods and services. That's going to act as a beacon, so they're going to keep coming back.
Okay, thank you.
Mm-hmm.
Awesome. Any other questions or comments from anyone? All right.
This was very helpful. I just would like to say that. Thank you.
Oh, you're welcome. Yeah, thank you for saying that. I appreciate it. I'm glad you found it so.
All right. With that, Linda, thank you. This was, man, thank you. This was spectacular.
I'm glad it was. I hope you had fun.
Listen, no, the notebook is full. It's full of notes at the moment. Yeah, some of the comments too. Thank you so much.
Oh, in terms of filing a trademark application, the United States Patent and Trademark Office is extraordinarily helpful in terms of their website. If you go to their website, you can, it'll say patents or trademarks. Go to trademarks. And even when I started out my practice, and this was, over 7 years ago, when I started focusing on trademarks, I went there and I started watching their videos. So there is a lot of information at the United States Patent and Trademark Office just to help you understand, hopefully take what we've learned here and really kind of solidify what a strong trademark is, the trademark application process. They have a flow diagram on their website to show you the trademark application process. And so please, I suggest if you are interested in knowing more about the trademark application process, please go to the United States Patent and Trademark Office, and their website will have a lot of information and videos for you.
Yeah. And with that, we are going to stop the recording.